Of course, you are welcome to the last legal prophet is, of course, the first and the last legal prophet, the man that originated from planet Jupiter to Mars, finally to Earth, the man that started to be a summa cum laude, a sui generis, with the help of God, we made it. I'll begin by saying that when you love the law will love you back. The law will never disappoint you. The law is so easy if you love it. Today, in this episode, we're going to talk about the historical development of the tort of negligence. So, the tort of negligence, many of you people have heard about it. Many talk about it, but many people don't understand the tort of negligence. So today, we're going to just simplify it. You're going to understand it. Of course, when I talk about negligence, it was clearly defined in the case of Lee Tang versus Cooper. You know the case of Lee Tang versus Cooper. So basically, when I just use my own understanding from the definition of negligence in the case of Lee Tang versus Cooper, they defined negligence to mean a situation where the defendant does an act that is below the standard of care, and as a result of the act, of course, the plaintiff, who in the law of torts we know as the tort feasee, because now that is the plaintiff, the tort feasee, suffers liability or damage. Now the question is, before Lee Tang versus Cooper defining, of course, and other scholars such as Jowells and Winfield coming up to define the definition of the tort of negligence, the question is, where did the tort of negligence come from? Did it exist? I will have to tell you that for those that did the historical development of the law of torts, you remember the stages in which the law of torts developed. That is in the world. We had the Gentile, we had the slavery, we had the feudal, we had the mercantile, we had the industrial capitalism. So the law of torts majorly, the tort of negligence, majorly developed during the stage of industrial capitalism. I'm not going to dwell so much into that. Why? Because that is not the reason as to why we are going to talk about, or that is not what we are going to talk about. So the tort of negligence majorly developed in the industrial capitalism era, or the era of industrial capitalism. So the tort of negligence, at first, it is also important to note that at first it was considered as an action on the case. When I talk of an action on the case, it was not in existence. So they decided based on the facts of different cases, meaning that their lordships, the House of Lords or the courts, whenever a matter involved issue of negligence, because it was not clearly defined, they used to distinguish or apply it based on the case. Each case, there was no principle of stare decisis, that is the principle of stand by the decision, because at that point in time, the tort of negligence was not in existence. Now, this tort of negligence, as many people, because for you to be held liable, something had to be direct onto someone, and he commits, basically there had to be a fault on someone which was directed to a particular person. So you're going to see that before the tort of negligence developed, there was no that this is where someone failed to do something without the intention of harming someone, and later someone gets injured. So many people, when they ran to court, they failed to win, or they failed even where it was res ipsa loquita, or where it was very clear that someone was in breach of their duty. They couldn't be blamed. Why? Because there was no fault directed on that person. So what the judges did, they saw that this act has become a problem. This act has become a problem. It is not later until the year 1883 it is not later until the year 1883 where Sir Balliol, Brett, Master of Rolls, Sir Balliol, Brett, Master of Rolls, in the case of Evans versus Pender, tried to now apply the principles of negligence. Actually, most of the people have a belief that the tort of negligence started or developed in the case of Donoghue versus Stevenson, but I should tell you that the tort of negligence started applicability, or they tried testing it. Of course, it was not successful in the year 1883, where Sir Balliol, Brett, Master of Rolls, in the case of Evans versus Pender. Please go and read about that full case. That is the case now. They try to say that no, let us change the dogma. Let us do away with this lacuna. Why would someone fail to act in a particular standard of a reasonable man? Because he did not direct the fault to someone and then he goes away without being challenged. So in the case of Evans versus Pender 1883, they started applying the principles of negligence. Of course, there was failure. In simple terms, in that case, it was basically about a ship. You have to look at that case of the ship where they had to tie it around the dock, but it went away, and then issues of negligence came in. But of course, it did not pass. Now, when it did not pass, of course, many people were victims or continued being victims of negligence, and they were not successful litigants when they ran to court. Now, it's not until the famous year 1932, where we see a man, a celebrated scholar, a celebrated judge, who we call Lord Atkin. At least every law student should know that guy, Lord Atkin. Why? Because he is the father. He is considered the father of the tort of negligence. So in the year 1932, you realize that that is the year where they had to come up with a decision in the case of Donoghue versus Stevenson. But in simple terms, without wasting time, you'll find that the tort of negligence was majorly, the case of Donoghue versus Stevenson involved a guy who bought ginger beer in what we call an opaque bottle. For example, when I talk of an opaque bottle, you will see, for example, this. Now here there is a drink I'm drinking. But what I'm drinking is from an opaque bottle. I cannot see what I'm drinking. I don't know whether you copy or you understand. So when this guy bought ginger beer, of course from an opaque bottle, he gets the bottle. Instead of him drinking the beer, he instead gave the bottle to a friend. Remember, the friend, who I will call B, did not use their money. It is A who used their money. So when he gives the bottle to B, he drinks. Now when B drinks the bottle, he finds that in the beer there were remains of a decomposing snail. Now when he finds the remains of a decomposing snail, he suffers liability, harm, damage. Now what he does, he runs to court. Now when he runs to court, at first these people had to do away with issues of, you know what, now let us bring in the principles of contract, because of course there was no tort of negligence. Why? It had failed previously in the case of Evans versus Pender. So they were still running on to that. So in the argument, the people who made the beer, they raised issues which we are going to see. What are the things that were discussed in the case of Donoghue versus Stevenson? I'll begin with what we call the privity doctrine. They discussed the privity doctrine. Whoever has studied the laws of contract, you know what is a privity. Mubufunze, a privity or privity doctrine in the laws of contract, it specifically tells us that a third party is not a party to a contract. What does that mean? That if it is me who bought this bottle and I give it to a third party, to another party to drink, it is not B who paid the money. So therefore, he cannot benefit from the contract. That is the private doctrine, that a third party cannot benefit from the contract. So these people raised that argument. Then there was the issue of the contract fallacy. You have to know what is the contract fallacy, as it was raised in the what? As it was raised in the case of Donovan versus Stevenson. Of course, the other thing that you have to know was that in Donovan versus Stevenson, they also had to talk about the principles to do with the tort of negligence. Negligence as a tort was now introduced. And now, when they raised the tort of negligence, that's when now we see Lord Atkin coming up to tell us that the tort of negligence has 3 elements. There is 1, the duty of care, 2, breach of care, and 3, damage for breach of care, which make the 3 elements of the tort of negligence. That's why you see, whoever begins discussing the tort of negligence, they talk about the case of Donovan versus Stevenson. Then the other principle that was discussed about in the case of Donovan versus Stevenson is the famous neighbor principle. Who is your neighbor in law? So when we talk about, or if we are to talk about the tort of negligence and the neighbor principle, I think let us meet in episode 2, where we are going to begin the tort of negligence, basically the element or the first element of duty of care. That's where we are going to talk about in depth the neighbor principle. Thank you for being a viewer, a good one, of course. Don't forget to subscribe, like, and comment. That is when we are going to know what you need, whether we are doing a service or a disservice. I remain the legal prophet. I sign out. Let us meet in episode 2.